Okay. Want me to just launch into it?
No, I just wanted to make sure that everybody's in. So okay. It looks like they're probably all in. All right, welcome. I'm Becky Moriello, and I'm an immigration attorney in Raleigh, and I am so excited that we are finally doing this presentation because this is a weird area. This is something that has somewhat blown my mind as soon as I first heard Greg talking about it. And I'm only coming from the immigration side of things. And, with the little bit that I know about family law, I'm like, wait, this makes no sense in the context of family law. And honestly, just on a human level, it also kind of doesn't make sense. So I'm really, really excited that we were able to get both of them in here. We've got Greg, the immigration lawyer, really focuses on these 864s, Val, who is a family law lawyer, also dealing a lot with immigrants. So this comes up a lot in her practice. They will both be introducing themselves. I actually, unfortunately, need to jump off. I'm glad I was able to set this up, but now I have a trial to get to. So I need to hop off, but I'm excited to watch the recording, and I will turn it over to them.
Thanks, Becky. And hi, folks. Val, we were just going to do self-introductions. Do you want to go ahead?
Oh, sure. Okay, so I'm Val Cicinelli. Some of you know me. I practice family law, mostly with the Latino community, which in the Triangle, it's mostly immigrants. I have been sort of dipping my toes in this topic because I've been helping out as local co-counsel for Greg. He, obviously he's the mastermind. He's the one who's going to tell you all about the immigration side of things and the form. I've been baffled by the intersection and also the obscurity of some of those decisions. I just read one decision that I couldn't even locate. Greg had to give it to me because it's like a bankruptcy court. I don't have access to, but it has a potential devastating implication for us. So I practice family law, and I am Val, and I'm done with my self-introduction.
And I'm Greg McLawsen. I'm an immigration attorney out here on the left coast. But in my defense, if you detect the smallest hint of a drawl in my speech, it's because my mother's from North Louisiana and I was homeschooled until high school. So I've been teased mercilessly out here in Yankeeville about my long A's my entire life. So I am a Yankee, I confess, but I grew up in a home of homemade gumbo and grits. So there's that. I'm an immigration attorney, but most of what I focus on now is federal litigation to enforce the Affidavit of Support, which is, of course, what we're talking about here today. So that Val and I can calibrate our comments best, could folks please jump into the chat function and just give us a one-word answer to your main practice area? Because if we have all immigration attorneys, I won't worry about talking about grounds of inadmissibility, for example. So if you could just use that chat function, it's usually on the bottom of your screen, depending on how you have the view formulated. While I wait for our answers to trickle in, here's the setup. So imagine you are a family law attorney, and this nice young lady wanders into your office and has an imminent divorce. She's been married for less than a year. Let's even say she has a significant educational and work background. Let's say she's a PhD nuclear physicist. And she asks you, what are the chances that I am entitled to some amount of alimony for the rest of my life? I don't practice North Carolina family law, but if it's anything like any family law jurisdiction I'm familiar with, the answer is there's no chance that you have, in a short duration marriage with the ability to support yourself, any prospect of having long-term, let alone lifelong alimony. You can't really answer that question, though, unless you ask your prospective client one important question, and that is, are you a green card holder? If the answer is yes, how did you get your green card? If the answer is through a family member, and usually here we're talking about a spouse, the answer to her question could actually be yes, that under federal law and under a binding contract created by federal law, she could be entitled to some amount of financial support for the rest of her life. And that's what we're here to talk about. The chances of this coming up in your practice are probably pretty good. Immigrants make up a significant portion of the US population. They come from all walks of life. So the chances of you encountering a green card holder, whether you know it or not, and you better know it because you'll be wanting to screen for this, are pretty good. So let's launch into the weird kind of hybrid immigration law, federal law world of the Affidavit of Support. We'll go over basically what in the world is this thing, what does it entail if the thing exists, what sort of compensation can the immigrant get out of it, and where do you even go to enforce this federal law thing that sometimes and actually usually rears its head in the context of a divorce. So I'll kind of focus on the federal aspect of that, and then I'll turn it over to Val to talk about some particular considerations you might want to think about in state court in North Carolina. What is this thing? Okay, looks like I'm just skimming our responses here. Looks like we've got a lot of immigration lawyers. Great. And immigration and family law. Okay, so basically I don't need to tell you folks what grounds of inadmissibility are. You know, they come in various flavors, one of which is public charge inadmissibility. If you don't know the history of this, by the way, this is one of the oldest codified aspects of federal immigration law. Remember, way back when, it actually used to be regulated by the states. When the feds took over, one of the very first laws that was promulgated prohibited the immigration of those deemed likely to become a public charge. And in rather crude lay terms, that means if you are deemed likely to be a drain on public resources, you are inadmissible. For years, the public charge determination was an ad hoc one. So there were no codified black and white requirements for passing public charge inadmissibility. And that changed in 1996. This was, of course, before I was practicing immigration law, but we all know about IRA, the 1996 legislation, which led to litigation. And Congress made a policy decision in 1996, and you can like it or not like it, but this is what it was. Remember that in 1996, we were concurrently revising our immigration system and also our public benefit system. Pardon me 1 second, I'm going to shut my blinds because my bald head is like shining here. Give me 1 second. It will be less distracting for everybody. Okay. So Congress revising immigration, revising welfare makes the policy decision that most federally funded means-tested benefits are going to be categorically unavailable to new immigrants. So if you've got a green card, you've been here for less than 5 years, sorry, you just don't qualify for things like TANF, federally funded cash assistance. Instead, Congress said that they would shift a new onus to visa petitioners. Starting in 1996, if you want to sponsor somebody to come to the United States, that's fine, you may do so, but you are going to be signing a binding financial support contract for that person. So the policy decision is basically, we're not going to make public benefits available to recent immigrants, but we got to give them some sort of lifeline if they really are hard up, and that's going to be the visa petitioner. What came out of that is the Affidavit of Support, required in all family-based immigrant visa cases and adjustment of status. If you've practiced immigration laws, it looks like most people do, you know that in all family cases with very limited exceptions, primarily those who have a 10-year work history in the United States. Everybody else requires this per se in the context of going through the immigration process. Who's the sponsor? The sponsor is always the visa petitioner. It might also, if that visa petitioner lacks adequate resources, be a joint sponsor. So primary sponsor can't show adequate resources to be that safety net for the immigrant, they can call in any friend or family member, doesn't have to be a friend or family member, any US citizen or lawful permanent resident living in the United States to be an additional resource to vouch for that immigrant. And they sign an additional affidavit of support. Okay, so visa petitioner signs the affidavit of support. Maybe you have a joint sponsor signing it. What does that even mean? There are technically three promises. There are two main promises that are made in the context of signing the affidavit of support. The third one is to update your address with the immigration agency. The first one is that the sponsor promises to repay the cost of any public benefits given to the immigrant. This is not something that we're going to focus on. One reason is that it just doesn't happen. So a federal, state, or local agency can sue a sponsor if the sponsored immigrant gets Medicaid. Well, remember, first of all, that the only reason this affidavit exists in the first place is that those recent immigrants are ineligible for public benefits. So it's no surprise that this probably doesn't come up very often, that a benefit has actually been given to one of those recent immigrants. But there are exceptions for domestic violence survivors who might be eligible for food stamps or TANF. But for whatever reason, most jurisdictions in the United States have simply made, as best I can tell, the policy decision of we're not going to do this. In my home state here of Washington, for example, our Department of Health and Human Services, they don't even have a policy on when and how they would do this. So if a DHS higher up were to turn to their legal counsel and say, hey, let's go get that sponsor, like they don't even have a policy or practice on how to do this. So this is in reality not enforced in the United States. The Trump administration flirted with the idea of making this mandatory, but even under the very stern immigration rubric of that administration, this never really saw the light of day. So we'll set that one aside. The second one is wholly different, however. In addition to that promise to the government to repay the cost of benefits, the sponsor also guarantees to ensure that the immigrant's income is at or above 125% of the federal poverty guideline. These get adjusted upwards minorly every year, but it's been, for the past 5 years, roughly $1,300 per month for a household size of one. Okay, so a promise to ensure that person has this meager but non-zero income. How long does this obligation go on? The statute, and this is mirrored both in the 8 CFR regulations underpinning the statute and also in the black letter terms of the contract itself, there are 5 events and only 5 events that terminate that sponsor's liability under the contract. Number 1 is if the intending immigrant becomes a US citizen. Remember, a green card holder never has a legal obligation to become a US citizen and can remain a green card holder for the rest of their lives. Lots of people do, because depending on the home country, you have to relinquish your original citizenship to become a US citizen. That's not true everywhere, of course, but countries to some extent like Germany, for example, or Japan. So lots of people make the decision not to become a US citizen. It ends when you are credited with 40 quarters of work. Now, note that I say credited because under the Social Security Act, one can be imputed with quarters of work earned by a spouse. And there's an entire corpus of administrative law. The Social Security Act's POMS, P-O-M-S, is the guidelines for how the Social Security Act administers this acquisition of quarters. It's its own super complicated area of law. But notice that 40 quarters and not 10 years is the end point here. So I hear a lot of times in the immigration bar that the affidavit of support terminates after 10 years. That's just wrong. It's wrong because 40 quarters, guess what? If you're not working, they're not accruing. That's what work means. So because the entire linchpin of the Affidavit of Support contract is a guarantee of providing income, the greatest liability is a situation where you have an unemployed recent immigrant. So that person is unemployed and is not working towards that 40 quarters endpoint. So that's another open-ended aspect of the contract. Number 3 is if the individual abandons U.S. residency and departs the United States. So this is important. A lot of times the context in which this affidavit comes up is when you have somebody on a 2-year conditional green card. That's for somebody who was adjusted to their status based on a relatively new marriage. So they get a 2-year conditional green card. The marriage is ending. And so then that person is transitioning from conditional to non-conditional permanent resident. And a lot of times in these cases, you'll have the defendant argue, well, they're somehow morphing to a new status from conditional resident to lawful permanent resident, and so that terminates the contract. No, in fact, they could lose their contract, their status altogether. They could have their 751 petition to remove conditions of residence denied and placed into removal proceedings. They could be subject to an order of removal, and they still would not have the I-864 obligations terminated because they haven't departed the United States. This 4th one I have never even heard of. The obligation terminates if the person is subject to an order of deportation and then in the deportation proceedings readjusts status based on a new affidavit of support. That is a legal possibility that I've never seen actually happen. And the obligation ends if either the sponsor or the intending immigrant dies. But that is it. Those are the only things allowed under the statute that terminate the obligation. Note the most glaring omission here, which is that divorce and separation does not terminate the contract. That is right there in the Affidavit of Support itself, to say nothing of the fact that it's reflected in the statute. And that is where these affidavits most commonly get enforced, is after somebody has gone through a marriage-based green card process, the marriage is ending, they aren't entitled otherwise to support from their sponsor, and so they bring up the Affidavit of Support. So this thing's been in effect for quite a while now, 1996. There are roughly 100 or so federal cases that are available, not published with a capital P in terms of in the West Reporter, but there's about 100 cases or so out there, including circuit law on this, in my circuit, not yours. But I can say that there are a number of very settled legal propositions about the Affidavit of Support. Number 1, it is, just as it purports to be, a contract between the sponsor and the United States government. And it is also clear that the intending immigrant, the green card holder, is a third-party beneficiary of the contract. So for those of us in immigration law who haven't thought about contract law since 1L year, normally if you had a contract between 2 parties, somebody outside of the privacy of that contract doesn't have any standing to do anything about the contract. But this is different because the contract expressly says, to say nothing of the fact that the statute expressly says, yes, it's a contract between the between the sponsor and the government, but we are very clear that the immigrant has standing to enforce his or her rights under the contract. And they have the right to recover damages. We'll talk about how those are calculated, along with all legal fees and costs associated with enforcing the contract. Just going to pause for a quick second to review a question here. I just want to respond briefly to Carson, who notes that he works with DV survivors. And I think we won't focus on this a whole lot during the presentation, but a vastly disproportionate percentage of the folks I work with in I-864 cases are coming from a domestic violence survivor situation, because this is a situation where oftentimes you have short marriage that falls apart because of abuse by the U.S. citizen. The person leaves, they're in a shelter, and because of that 1996 legislation we mentioned, they don't have anything else to turn to. They don't qualify for many public benefits. And so this is really a super important lifeline for survivors. And it's been a drumbeat I have been beating for 5-6 years now to try to get more advocacy organizations on board with screening for this, because you could do it with a couple questions. Are you a green card holder? Did you get your green card through a family member? Okay. Are you broke and unemployed? Well, we should talk. This is not hard to screen for. And if Carson, you're with a nonprofit and plugged into the community, please try to get your nonprofit partners out there on board with screening for this. They could do it in 10 seconds for each new client. And for those who have these rights, it could be a really big difference in their path back to self-sufficiency. So off my soapbox and back to black letter law. Oh, sorry, let me answer a question from Anna. Must the immigrant adjust based on the petition? Okay, yeah, so here's the bad news. I'm going to make this tailored to the immigration lawyers who will follow the technical speech, but you have a question here where, let's say there's a marriage, US citizen, foreign national, we have a pending adjustment of status application, and while it's still pending, things implode. What's common in that situation from a legal standpoint for the survivor foreign national is that they would then switch immigration strategies to a VAWA I-360 self-petition. From an immigration standpoint, that makes absolute sense because you've got a pending marriage-based I-130 and you're worried that the I-130 isn't going to get approved if the spouse is out of the picture because he's an abusive jerk. That makes sense from an immigration standpoint. Unfortunately, as regards the affidavit of support, the contract says that the individual must gain status based on the affidavit of support. So I think natural reading of that, this hasn't been tested in cases I'm aware of, but the natural reading of that is that you would have to acquire LPR status based on the I-130 filed by the family member. So if you instead switch strategies and adjust based on the VAWA 360, that probably cuts off your ability to pursue rights under the affidavit of support, which is a bummer because that really does happen. And I think Val was rightly outraged when we were talking about this, because it seems like the situation where the person is most obviously entitled to support, but it's not clearly the way the statute is written. So at least in theory, and the devil is always in the details on this, the damages are easy to determine as to what the beneficiary can recover. Recall that the obligation that the sponsor has is to maintain the immigrant's income at 125% of the poverty guideline. Okay, so the damages that they can recover are, let's take their income, let's compare it to 125% of the poverty guideline. Whatever the difference is, that's what they're entitled to. Pretty easy. That's the black letter law measure of damages in these cases. So the easiest ones, of course, are when the person's just unemployed, where we've got the situation where somebody's been unemployed for 11 months. Well, multiply out 125% of the poverty guideline for 11 months, and those are your damages. But again, the devil is in the details. So what we get into fights about in settlement talks and in litigation is, well, what's income? Because unless you are dead, which fortunately my clients are not, you've been living off of something, right? You're living in a shelter, you're going to a food bank, you're crashing on somebody's couch, you're living in a car, you're getting something from somewhere. A lot of times for my clients, that's gifts from friends and family, it's loans, it's informal work, it's gig work. So which of those various forms of economic goods serve as income? because if they qualify as income, they effectively offset the sponsor's support obligation. Well, thankfully, the regulations define income at CFR 213A1. That's a long definitional section for the Affidavit of Support and its associated terms. And it says income means taxable income. Well, great, because we've got our own rules about what is and isn't subject to federal income tax. You would think that would make it easy, but courts have taken a broader, I will call it, in charity and equity-based approach. So they look into the crystal ball of fairness to determine what qualifies as income. For example, they might say that if my client is crashing on the couch of somebody's extra house, they will impute to my client the fair market rental value of that house. Well, I think that's crazy, but that's how some cases have shaken out. The cases that say that, in fact, I typically don't even cite to this regulation. My own suspicion is that, so 54% of these cases are brought by pro se litigants. And I think a lot of the bad case law in these cases is because you got a foreign national pro se litigant trying to prosecute one of these cases. So that is what it is. Anyway, that's a major kind of red herring in terms of how these cases progress, what qualifies as income. So damages, you've got existing, we'll call them support arrearages. That's a family law term, but it sort of makes sense to import it here. Those are in principle easy to calculate, 125% of the poverty guideline minus actual income. But actually, the significant value of a lot of foreign national claims is in the future value of their claims. Because let's take an example of a client I had from Gujarat who came over here on an arranged marriage that very quickly fell apart. She didn't speak English. She didn't have any educational background. She didn't have any work background. So she had just moved out of the abuser's house. So her existing legal claims were for a couple $1,000. But she had this long road ahead of her where she's not going to be employed. She doesn't speak the language. She doesn't have any idea how to function. And this was in Oregon. So in a lot of these cases, and this is important in the context of the negotiation process, the principal value of the claim that we're talking about is in those future support claims that we know the person is very likely to have down the line. And when we're valuing those, in large measure, what we're asking ourselves doesn't have anything to do with those 5 terminating events. The real question is, when is this person going to be back into gainful employment? Because once they're earning over 125% of the poverty guideline, that effectively nullifies their entitlement to support. So when you're looking at these cases, the real question for prospective valuation is, when do we think this person will be back in the workforce in a meaningful way? So you got this person in front of you, sponsored immigrant. Obviously the I-64 was signed. Let's say they're unemployed. Where do you go to enforce your contract? Well, the obvious answer is it's a federal statute. Right there in the statute, at subsection E1, it says, hey, foreign national, you've got the private right of action to sue. So obviously, in my mind, and obviously to 98 out of the 100 or so cases that have addressed these claims, it's clear that there's a federal private right of action. And so you've got federal question jurisdiction to get into federal court. There are 2 unpublished district court cases in the country that hold to the contrary, one in Middle District of Florida, one in Colorado, both of which say that these cases sound exclusively in contract law, and so they are state court cases absent diversity of parties, but that is a minority view. The majority view is that these are federal question cases because the federal statute creates the right of action. But merely because it's a federal statute does not mean that you can't go into state court. A lot of times when I'm talking to state bars about this, there's this refrain of, like, it's a federal statute, so it's for federal courts. No, that's not how it works. there is a presumption in civil procedure of concurrent jurisdiction. State courts of general jurisdiction can always hear federal statutory claims unless the federal statute expressly strips the court of jurisdiction. And there's nothing like that here. So you can absolutely walk into state court and file a breach of contract claim. You don't even have to cite the federal statute if you don't want to, because the contract is clear on its own four corners. It's just a breach of contract claim, and just use the I-864 like you would any other contract. I've done them in state court. The reasons that I do it in federal court have more to do with strategy and logistics than anything to do with being worried about getting bumped out of state court. And in fact, the North Carolina Court of Appeals has a case directly on point on this. And the plaintiff in Zoo did exactly what I just said, which is they just walked into state court and filed a breach of contract claim against their sponsor. It's an interesting case for a couple reasons. It held squarely that the defense of unconscionability doesn't apply in affidavit of support cases. That's in accord with every other court to consider that proposition. And most importantly, the Court of Appeals held that the duty to mitigate doesn't apply in these cases. Any family law attorneys will understand that that is a big deal. What it means is that when it comes to calculation of damages, we are not going to play this goofy counterfactual game of, well, is your client actually voluntarily unemployed? I've got a client in Minnesota right now who the defendant keeps saying, you know, she could work if she wants to. She's a Japanese citizen who just doesn't get it. You know, she doesn't get how America functions. Well, what cases like Zoo say, and there's also a Seventh Circuit case, Leo v. Munn, that squarely holds the same thing for the Seventh Circuit, is that we just do not play that counterfactual game in the context of affidavit of support cases. Why? Because Congress wanted to ensure that this class of recent immigrants has actual financial support. So the question is not, could the person hypothetically be working and they're actually being sneaky and trying to live off of $1,300 a month because they're lazy, et cetera? No, we're not going to do that. When it comes to their claim, the question is, do they have income? Answer no. Then you have damages, end of story. So that's strong precedent in the state of North Carolina. I don't know of any published state court decision that's quite as squarely on point as that. And Zoo also said, and this is absolutely consistent with the way the regulations are written, that assets and income are treated completely different when it comes to affidavit of support purposes. So if you have an immigrant who has significant assets, it doesn't change the calculation of damages, because the calculation of damages turns exclusively on what the individual's income is. So if you want to, as the defendant, you know, lob allegations that the person has secret offshore funds or they have a really expensive jewelry collection or whatever, it doesn't matter. It doesn't matter, because that's not how damages are calculated under the contract. And that's great news from a plaintiff's standpoint, because it makes the whole thing that much easier. I have much more that I could get into here, and I will jump into the comment section to answer the issues that have come up so far, but I will turn it over to Val to highlight some issues of particular interest here. And Val, it doesn't look like you're muted. And if you want to, for any reason, I can always just advance slides for you.
Can you see me, Greg? Can you hear me?
Now I can. Do you want me to just advance slides for you?
No, because I changed them.
Okay.
Can you refresh? Can you refresh your Gmail?
Oh, yeah. We're working off of a Google slide deck, so.
If you refresh it, I'll see what's next here in my.
And you might have to press Control R2 to refresh. I just did it. So Val's.
Apologies, I've never done this shared host thing, so I'm trying to figure out how to go back to my.
Let me. I should have your changes. I see your changes with the earlier case here. So let me just go ahead and share mine, if that's okay. You want to do that? Here we go.
Yes, perfect.
Now you're back in Earlerville.
Okay, can everybody hear me? Yeah, okay. All right, so I think the basics of what you heard, obviously, if anybody's know anything about family law, it resonates with alimony, it's spousal support in the case of a marriage, right? We know that it can be other sponsors, but it's not a spouse that's the sponsor. But because I do family law, I'm going to be talking about what's the impact for family law and the rights of spouses. So when these two issues conflict, when there's a sponsor and a beneficiary in separating spouses, they should become, how does this obligation of support relate to this other obligation of support? Is all money. Money is fungible. So it's going to come from the same person going to the same person. So that reality needs to be parsed out in legal terms. So I'm going to start from the beginning. Like, people go into a marriage sometimes with a contract. So we have the spouse who comes to the U.S. under an I-864 base, and obtains citizenship with a contract that the other spouse signed. Well, they go into a marriage and they sign a different contract between the two parties. So you're going to have the same issue of support sometimes in the prenup agreement. You might have support issues, but these obviously are not the same parties. So as Greg explained, the government and the sponsors sign a contract, and now we have the spouses between the two of them, wife and husband, or whatever it might be. So it's not the same. So basically, the law here, the result, it's a logical conclusion. No, only the government could potentially waive, make any arrangement for this contract that happened between the contract and the government, the sponsor of the government. The spouses can make other arrangements, but it cannot modify the immigration contract. They cannot modify the rights of the beneficiary under the I-64 form. So it's a short answer, no. The litigants cannot, parties cannot modify the obligations. They cannot waive them. The beneficiary cannot say in a prenup agreement, I relieve you from your obligation that you promised the government. Obviously, there are overriding public policy decisions that went into the creation of that law, and that's why it's created like that, the same way that we don't have some available contract defenses in a regular contract. But even at the contract law, if you are not party to a contract, you cannot modify it. So it makes sense that the answer is no, you cannot modify. Now, in North Carolina, we cannot waive alimony completely. We can waive alimony, but there are caveats that we cannot waive in a prenup agreement. It is irrelevant in this case because by federal law, this cannot be waived. So we can go into the next slide. Craig, do you mind? So separation agreement, and that's when things start to get a little muddy, because we could obviously waive alimony in a separation agreement, but can we waive the A-64 obligations and rights? Well, as Greg was saying, we can get into a global settlement to waive future claims. However, not the fact that we're waiving alimony doesn't necessarily mean that we would have waived the I-64 rights. And that's when, to me, it starts to be a minefield for the family law practitioner who is representing sponsored or a beneficiary or a sponsor, because are we not waiving the I-64 rights? These rights are very different. As Greg was saying, the issue of mitigation, it's central to an alimony claim. If you're not looking for work and you have the skills, the court is not going to say, oh yeah, sure, let's let the other person completely support you for the rest of your life so you don't work. Well, guess what? The I-864 works like that because of the public policy reasons that Greg just described. So we are considering as family law practitioners a separation where somebody already assumed a support obligation under contract with the government. We have to be very mindful of what are we agreeing to in terms of alimony, because as I said, money is fungible. It's going to happen for the same person to the same other person. So sometimes not. It could be that under family law, one person is supposed to be the sponsor, the supporting spouse, because they have been a supporting spouse, and there's a state law definition of that. But under immigration law, the other person is the sponsor. So how do you do that? How do you manage that? Do you net it? You can't net it, because remember, you can't modify the government contract. So I think that's sort of a minefield, and I don't have the answers. I'm just saying it out there. I think there are considerations that we have to, I have two of those cases right now. For example, it is possible that your client in the family law case, it's not a dependent spouse, or they have committed marital misconduct, which under certain circumstances that will bar them from receiving any alimony. But they're not barred. I mean, misconduct, it's not one of the 5 terminated events. So neither is failure to mitigate. So neither is being a dependent spouse. So those issues are intertwined, but it's the same money. And so there are a ton of, if we can go to the next slide, there's a ton of considerations to juggle around when we're trying to decide where we're going to file a domestic, we're going to include a domestic claim into a domestic case. In North Carolina, we can go to Superior Court, or there's concurrent jurisdiction for District Court and Superior Court and state courts to file a breach of contract. Now, based on my research, my limited research, and the research that Greg had done before, there's one big case that was decided in North Carolina. It is very important. The Zoom case that Greg just presented, it's out of Wake County. This is Judge Worley. It's just a judge. I have had cases, and she is actually really good at novel manage. I had a couple of novel issues of first impression with her. She's really good. She delves into the law. I am, and then she still got it wrong. I mean, that her decision was reversed. She found in district court that the beneficiary had a duty to mitigate, and an appeals court said, no, there's no duty to mitigate. We cannot read into the statute something that is not in the statute. So it is very important, because as family law practitioners, we can say one of our biggest counties, one of the judges has been there forever, has taken into this claim together with the domestic claim, has decided on it, and there's a direct ruling. There's other things in there in that case that are important too. For example, property division, which is what Greg was mentioning, doesn't affect what that's there in the Zoom case. So it's very important. And we're, this is the case of Wake County, the Fourth Circuit. So everything that's going to happen in North Carolina, which is part of the Fourth Circuit, even if we're in district court and federal court, we have it right here. So it's our contracts law, it's included in that case, as well as the Fourth Circuit law. So the problem with this is that when we file a claim for I-64 in a domestic case, we have to be very mindful of full faith and credit doctrines, because if we file now in when we're asking for support and we include the support, our judgment might include a decision on the present rights of the beneficiary on the affidavit or not. Just to give you an example, can we go to the other? I don't know. Normally I will be flipping the slides to go with what I'm saying, but it's what it is. Okay. So we can say there's a lot of advantages of including this claim from the very beginning when you have a family law client, but this increased the leverage. As I said, there's no mitigation obligations. There is no misconduct that's going to affect this support obligation. And you don't even need to show that you were a dependent spouse during the marriage, which is a complicated concept. You just are owed this money without any of that. So potentially, if somebody was married 5 years, and we say here, Wake County, in alimony, the rule of thumb is half the length of a marriage. So if, let's say, we potentially and this person can stay at home and not work for the rest of their lives, unless the other events take place, but they can not work under the government contract compared to maybe 2 years that they're going to get in alimony. So when we're setting to negotiate, even if we're not filing anything, we're going to say, well, wait a minute, you want to give me 2 years of alimony? No, because we won't take that. We will go and fight you in under the affidavit of support and get potentially forever alimony, forever support. So let's talk about this out again. I don't want 2 years of alimony, I want 20. So that claim is a completely different conversation. And that's why I feel it's so important for family law practitioners to know this. And as Greg was saying, it's just 2 questions. Are you a green card holder? How did you get it? And, if they don't know, send them to an immigration attorney, but I think it's important that we all work together in informing the family bar, because a lot of people could be putting themselves out of their, the potential of this form, they could be losing it. And I'm not going to tell you into much details, but that happened to me. I did not know this existed. I waived alimony in a separation agreement. I didn't know it existed or how it worked, and I became a citizen. And so I have, there was, it would have been great to count with this. I was just an attorney. I could have worked under any of those wonderful people that run this CLE for free. So I could get support, plus my child support. I was okay. I would have trained myself as opposed to have to make money a year after my divorce. So this is fundamental. This can change somebody's life.
Hey,
okay,
Val,
so
can I make a quick plug? Can I make a quick plug? And folks, if you have like a potential case, like just shoot Val or I an email. Like, we're happy to help you take a look at it. It takes me like 5 minutes to help you figure out if you've got a potential claim here or not. It's not rocket science to figure out if you've got a potential claim or not. I mean, we're happy to help you get to clarity on that.
Yeah, absolutely. Nobody needs to be an expert on this. It's just very easy to ask, Mr. Greg. Okay, so what I was saying, the problem is, okay, we include the claim, right? We said we're going to include the claim. It has a lot of advantages. I'm looking at the time. I don't want to go into detail, but we do always need to keep in mind that when something was litigated, there is going to be a preclusion on the other side. Like somebody, for example, we decide to litigate this in state court, and the state court might have gotten it wrong. However, I might not have the option now to switch gears and go into federal court, different forums, and relitigate. There are many issues that are going to be playing into the family courts. We have issues of child support. We have issues of mitigation, which are issues of property. It's a new area of litigation. As Greg says, maybe 100 cases that have been out there. So what are the chances the state court is going to get it wrong? And it's going to say, I don't have jurisdiction. In fact, there's a case that blew my mind that I read last night, and I asked Greg, can you send me the pleadings? And when I saw it, I was like, oh my God, basically plaintiff wanted to litigate it with their family case. The courts say, district courts say, I don't have jurisdiction. They went to bankruptcy court. He tries to bring it out again. District bankruptcy court say, I don't have jurisdiction. Well, when this is all over in domestic court or bankruptcy court and then domestic court, they go to federal court. Plaintiff tries to enforce the affidavit, and the court, what did it say? The Second Circuit said it's litigated. Res judicata. This been decided. There's all these doctrines, the Rooker-Feldman doctrine, the res judicata, claim preclusion, and collateral estoppel, issue preclusion. These three doctrines bar in the federal court's decision their opportunity to revisit this. Although nobody had revisitation. On the other end of the spectrum, can we go to the next one? Greg, any chances you can? Oh, okay. So this is the case that I was just talking about. This is Schwartz. I understand this is came from the bankruptcy court, but it's in the Second Circuit. So it says, I'm going to read the quote because it struck me as such a warning sign for family law practitioners. Says the divorce proceeding clearly, and I just told you guys what happened procedurally, right? Nobody wanted to hear this claim, and this happened in the appeal. The divorce proceedings clearly involved the appellant's claim for support from the appellee, right? There were alimony issues. As Davis demonstrated, a party's support claims under an affidavit of support can be adjudicated as a part of the party's claim for support in a divorce proceeding. It's a can, right? It's can, it wasn't, but could have. Although it is unclear whether the appellant actually submitted the affidavit of support in the divorce proceedings, there were differences about this. She clearly could have done so. Therefore, since the appellant could have pursued her support claims under the affidavit of support in the divorce proceedings, she's barred from pursuing those claims in the appellee's bankruptcy case under the doctrine of res judicata. This is crazy. Nobody actually litigated these cases. This person tried. The court said they didn't have jurisdiction because it was an immigration issue, said district court. Then bankruptcy court said, well, district court doesn't have jurisdiction. I don't have jurisdiction. It was nobody litigated this. The claim was relinquished basically. And that had to do with particular missteps that the party had. She didn't know the affidavit existed, and when she existed, they presented it late. But if you are a family law practitioner and you didn't screen for this, you might as well committed malpractice. We all should know first that this existed, right? That's what I'm saying. I think the first step is to say, we need to get the word out there that whomever is going to touch a family law case involving an immigrant, they need to educate themselves. Or like Greg said, reach out to us or somebody who knows. And it's very important. If you're an immigration attorney and you have, colleagues that aren't family attorneys, just alert them to this, that whatever they have, immigrant clients, they have to inform themselves or just bring them to something who knows. All right, so.
Next slide.
Yeah, we're almost out of time, so I just want to finish. So the last thing is children, when they are sponsored, they also have these rights. And oftentimes, and I have a lot of those clients as well, a sponsored immigrant comes from someone with their own child, from a different parent, and are sponsored by a new spouse or a new relationship or somebody who they're going to marry. Well, those children might not have a right to child support from this father, from this new sponsor. I'm just thinking if this is a mom with a child, well, they do have rights under the IAC4. Now, there are issues of, like the next slide. Can we put the next slide? Sometimes my last slide. There are issues with attorney fees who are very different from what we can, between what we can do in this federal form versus what we can do in domestic court, because we're not allowed to get contingent fees. So as Greg said many times, many times when we're settling, many times future fees are important. Well, if you have to go to federal court to settle the future fees, you're going to end up, the litigant might end up paying their attorney a portion of their award, which it won't happen necessarily in, it won't happen in domestic court because we can't charge contingent fees in domestic court. So I don't know, there's not a case that I could find in North Carolina where they try to get a contingent fee, an attorney tried to get a contingent fee out of the affidavit of support litigation within a domestic case. There's one case that I was able to find. There's the one that Greg presented. I don't know how that will work, but domestic attorneys cannot change contingent fees. So the value of the claims, all of this is to say that the consideration of whether to file this claim with a domestic claimant is important. And there are a lot of pieces and parts and moving parts. And somebody with an immigrant client who's at least screen for this. And if they see that they might qualify, then they need an expert. They need somebody who knows how will this impact their case. And that's it. That's all I got.
Let me just riff on one thing, Val, since you mentioned the Schwartz case, which that was a bankruptcy circuit panel case. So one question that we get a lot is, how about dischargeability of these claims? And the only two bankruptcy decisions on point both hold that these are non-dischargeable domestic support obligations. So to the extent Val was absolutely correctly sending home the message of take this seriously and have on your radar, that this could be a big exposure if you happen to miss it in the context of a family law case. The claim's also non-dischargeable, so the sponsor is not getting out from under this claim, period. I've answered a number of questions in the chat function here. We can certainly open it up to more questions. We're basically at the end of the hour. I've got some flexibility. I'm totally happy to stick around if there are questions. I will not take everybody off mute, I think, because that tends to create total pandemonium. But if there are more questions, feel free to jump into the comment box. And Val mentioned that there are a few cases she's working on in family court. We have a couple cases together, which has been a total pleasure, Val. Been really nice working with you in federal court there in North Carolina. So, I mean, just here, like this is a real thing. This is not some kooky academic, law school hypothetical what if sort of situation. These cases are happening. Val mentioned the exposure for attorney fees. Courts with 100% consistency have awarded fees in these cases. If a sponsor is smart and has a good lawyer, they will settle the claim and not fight in federal court. In that case, their fees might be $2,000. If they do fight, then you get the Dorsenio case that we had in California, where the guy fought and lost. And he was up to about $150,000 in our legal fees when we foreclosed a house of his. He was up to about the same amount of fees on his side for his defense attorney, who he then turned around and sued, saying, why in the world did you let me litigate this in district and circuit court when I was going to lose all along? And we're like, yeah, that's what we said. Yeah, they're loser cases for the defendant. Anna asks, do these cases settle? It's really like civil claims writ large, which is that most of them do settle. A minority of ours settle pre-filing. So the occasional one will settle pre-filing. Usually there has to be kind of the 5 stages of grief on the other side. So the defense attorney who has never ever seen this before comes back and says, not only are you going to lose, but your claim is so totally bogus and out of the blue that we are going to file CR 11 sanctions against you if you even think about filing this complaint. And we say, you might want to look at these cases that we cited in our demand letter. And then complaint gets filed. Of course, it doesn't get dismissed because it's black letter federal law that we have the right to bring the case. And so maybe after some dispositive motion practice, then like reality settles in and the defense settles. That's where most of them get resolved, is after a round of dispositive motion practice, often before discovery. We have one case in the entire country that is set for trial. I won't comment on it because it's an ongoing piece of litigation, but that is one case that I have seen go to trial in my practice. Can the petitioner spouse depend on her immigrant spouse to meet the income required for the affidavit of support? Yeah, so that, I mean, that's an immigration law question that goes to filing the affidavit of support in the first instance, and the intending immigrant's U.S. income. So this is really only for adjustment of status cases. The intending immigrant's income can be used without the need to file an I-864A. However, none of that changes the sponsor's support obligations. So even if the sponsor met his or her financial sufficiency requirement by relying on the immigrant's income, as might have been the case for Val, who's an attorney and earning income, it doesn't change anything with respect to the affidavit of support obligations. The biggest issue that we get into when the sponsor has insufficient income is bringing in the joint sponsors. I didn't say this clearly enough earlier, my apologies, but the joint sponsor is jointly and severally liable, period, end of story. So the plaintiff immigrant may sue the sponsor and the joint sponsor, or may sue only the joint sponsor because that person has the absolute same exposure on the contract that the sponsor does. Okay, how do you get a copy of the affidavit of support? So this is a great question. Here, I'll mention three things about this. First of all, as a practical matter, we can typically get the I-864 from USCIS via a FOIA request. My reading of the Privacy Act is that CIS should be redacting the information of the I-864 sponsor when they give us, the immigrant's attorney, the affidavit of support. But for whatever reason, maybe because the federal government is the federal government and is imperfect, we get the whole thing. So at the beginning of every single case, we request an A file, and usually we get the unredacted I-864 with all the tax records for whatever reason. The 8 CFR regs also authorize a judicial subpoena for a certified copy of the affidavit of support. It has been the practice of DHS counsel, as a matter of course, to resist those on Tuffy grounds. If anybody does federal court litigation, basically the rule is if you can get the records elsewhere, you have to do so before sending us a subpoena. That's kind of crazy because USCIS's own regulations say that we can subpoena the record, but there's that. So we can always get it one way or the other from the alien file. The third route, and this is what Anna raises, is, well, what about if there's been a previous attorney of record in the immigration case? Can we request the file? I was doing a 50-state case law review on this for a journal article before I decided it was just way too much work and wasn't going to be all that helpful. But the law in every state that I got around to reviewing is that if you have a joint representation, so attorney is representing sponsor and immigrant beneficiary, there's an equal duty as attorney to both of them. That includes an equal obligation to disclose the file to either one. So it is black letter law, as best I can tell, that the immigrant beneficiary is entitled to the affidavit of support, just like everything else in his or her file. Now, if the immigration firm, and I think this is often, screwed up and didn't bother to advise their clients about the risks of joint representation, I'm sorry, that sucks for you. You should probably change your intake process and representation agreement, but it's not my problem, and it's certainly not my client's problem. They are entitled to their client file, including the affidavit of support. This is a fight that I've gotten into with some pretty prominent immigration firms in New York and Florida, both of which told us to pound sand and would not give their client a copy of their own file until some serious saber rattling took place and they got on the phone with their ethics counsel and realized, oh, shucks, we do need to do this, and give over the file. What if the sponsor did not have income and they obtained a joint sponsor? Does that change the sponsor's obligation? It doesn't. This is a question from Dahlia. As a practical matter, that probably means that the sponsor is judgment proof. So in reality, what we would do is sue the sponsor and the joint sponsor. I, again, won't comment on ongoing litigation, but for strategic reasons, we have learned the hard way that in some cases, if we've decided that the sponsor is judgment proof, it's going to make a lot more sense to just go after the joint sponsor. Historically, I've had a little bit of concern that the joint sponsor would make an argument that the sponsor is a necessary party, but I think that's obviously incorrect for a variety of reasons. So you would just go after the joint sponsor if that's the person who has actual resources. What about the joint sponsors? And Val, if you wanted to answer any of these, sorry, I'm just kind of blowing through them. If the joint sponsors request that the applicant never see the affidavit of support, like an employer, is it possible effectively for that joint sponsor to hide the affidavit of support from the sponsor? So certainly, let's say we've got a consular processing case. So benevolent employer steps in, and this happens a lot. Benevolent employer or community member steps in and files an affidavit of support. They file it directly with National Visa Center, so the immigrant's never seen it. What does that person do? Same thing as before. We could FOIA the alien file. That's probably going to get us what we need. We can subpoena it from DHS. That's probably going to get us what we need. And at the very worst, we could, in the discovery process, of course, compel that defendant joint sponsor to file a Privacy Act / FOIA request with us to release the affidavit of support. Why? Because it's in their control. If the reason we can't get it from the alien file is the joint sponsor's information is redacted and they're a defendant in the lawsuit, we can definitely, because they've got the permission to release it, even if they didn't retain a copy, we can get them to cooperate with the FOIA request from DHS. As a practical matter, I would say we don't sue benevolent community leaders who help out clients. This almost always comes up in the context of a family member who's sponsored the intending immigrant plaintiff. Give it just a couple of seconds in case anything else comes in here. And again, if folks come up with real questions or hypothetical questions, or you've got potential clients, my website, I think, is at the beginning of the slides, and just shoot me an email. I'm happy to answer questions. I think Val and I are both pretty easy to find on the internets. Final words of wisdom, Val?
Sorry, what?
Any final words of wisdom? I think Becky's not online.
No, I just encourage everybody just to reach out. As I say, I'm just learning about all these things, but I have a lot of thoughts in how this can be handled. Some of them I tried in a couple of cases of mine, but we can think together. So give me a call. Call my office, say you're an attorney or a paralegal, whatever, and I will just jump on the phone with you, and then we can think together through some of it. Some of the stuff there is no case law, so it's going to be kind of from the family law side. So we're going to have to strategize. We can strategize together, see how we can figure it out. So that's it.
But a lot of this does have black letter answers, and it's just answers that folks oftentimes aren't thrilled to hear, especially if you're got a defendant sponsor sitting in your office. Thanks, Skull. Thank you all very much. Pleasure to talk to you. Wish I could be doing it in person. I would love to be in South Carolina right now, but c'est la vie. It's been an interesting year. I guess since we are both co-presenters, Val, I'll go ahead and log us off. Okay.
Bye, everybody. Have a great day.
Take care.